Welcome. Today, we're wading into the murky waters of business competition. We're going to figure out where the line is between being a savvy competitor and being a saboteur. It's all about something called economic torts, basically the official rulebook for playing fair in the marketplace.
All right, let's just jump right in with a scenario. Imagine you're the boss. You have a star employee, let's call her Sarah, and she's the brains behind your next big project. A rival company knows she has a solid 2-year contract with you, but they swoop in, offer her a ridiculous bonus, and poach her. Just like that, your project is dead in the water and you're looking at a massive loss. So, what do you think? Is that just the cost of doing business, or did they actually break the law?
Well, the answer to that question lies in the world of economic torts. You know, most laws are about protecting you from, say, physical harm or protecting your property. These laws are different. They're designed to protect the financial lifeblood of your company, your deals, your client lists, your future opportunities. They cover what the lawyers call pure economic loss, which is really just a fancy term for lost profits and business that you should have had.
So how does this all actually work? It really boils down to 2 big categories. The first one is the most obvious. It's when someone messes with a deal that's already signed, sealed, and delivered. The official name for this is intentional interference with contractual relations.
And you know, this whole idea actually goes way back to 1853 and an opera singer. Seriously, a theater had an exclusive contract with a famous soprano. A rival theater owner, this guy named Guy, convinced her to ditch her contract and sing for him instead. The court made this landmark decision. They said the first theater could sue not just the singer, but also the rival who talked her into it. And that's how this whole concept of inducing a breach of contract was born.
Okay, so if you're the one suing, you've got to prove 5 things. 1, you had a real, valid contract. 2, the person you're suing knew about your contract. 3, they did something on purpose to cause it to be broken. 4, their actions were improper, and we're going to circle back to that word because it's the absolute key to the whole thing. And finally, 5, you have to show you are actually harmed, that you lost money because of what they did.
So what in the world does improper actually mean? Well, it's not some simple checklist. It's more of a balancing act for the courts. They're going to look at why the defendant did what they did. Were they just trying to compete, or was there some malice involved? They'll look at how they did it. Did they use lies or threats? And then they zoom out and look at the bigger picture, balancing the need for fair competition against the need to make sure contracts are stable and reliable.
Okay, but what about the deals that aren't quite signed yet? The handshakes, the promising leads. This leads us to the second big category: interference with a prospective economic advantage. This is all about protecting the business you have coming down the pipeline.
What this really does is protect your reasonable expectation of future business. You can think of it as a shield for your almost contracts. Those situations where you're right on the verge of closing a big deal, or you're the clear frontrunner for a new project. Now, because we're not talking about a signed contract here, the legal bar is set way higher. You can't just sue your competitor for being more persuasive in winning a client over. No, to win one of these cases, you have to prove their actions were independently wrongful. That means they had to do something that's already illegal or a tort on its own. We're talking things like fraud, defamation, or even physical threats.
Here's a perfect example. Let's say your construction company is about to land a massive contract. Your rival finds out, so they write a fake letter and send it to the client, claiming you used terrible materials and cut corners. The client gets nervous and, well, you lose the bid. That lie, that defamatory letter, that's the independently wrongful act that makes it illegal interference.
So, you can see the really crucial thing here is to understand the line the law draws between tough, healthy competition and illegal interference. Let's break down that critical difference.
This really spells it out. For existing contracts, think of them as a fortress. The deal is sealed, protected. All you have to show is that the interference was improper, and the excuse of, hey, I was just competing, is probably not going to fly. But for future deals, it's more like a blueprint. It's just a plan, a potential. Here, the interference has to be something nasty and wrongful on its own, and arguing that you were just competing fairly is a much, much stronger defense. And honestly, this is where so many businesses get tripped up. They fail to see the difference between these 2 situations. Your entire legal approach has to change depending on what you're trying to protect. Is it a sealed deal or just the potential for one? That's always the first question you have to ask.
But wait a minute. Are there ever times when interfering with someone else's business is okay? And the answer is yes. The law actually recognizes certain justifications or privileges for doing it. The #1 defense, by far, is the privilege of competition.
The whole system wants businesses to compete. So if a new coffee shop opens up and starts stealing customers from the place across the street by offering better coffee at a lower price, that's perfectly fine. That's just fair competition for future business.
But, and this is a huge but, there's a very bright line here. That privilege of competition pretty much vanishes when you're talking about an existing, signed contract. The law basically says, compete all you want for new business, but you can't just go around rating your competitors' signed deals.
And there are a few other justifications too. For instance, you might be allowed to interfere if you're protecting your own legal rights, or if you're just giving truthful, honest advice that someone asked you for. Even something as big as blowing the whistle on a public safety issue could be a valid defense for messing up a company's contract.
So let's just boil this all down. At the end of the day, the law of economic torts is trying to do a tricky balancing act. It wants to encourage a free, open, competitive market, but it also needs to make sure there's some stability and trust in business. It's all about drawing that line between playing hard and playing dirty.
And that kind of leaves us with one big question for today's world. These rules were created in an age of opera singers and shipping contracts, but how do they hold up now? What does improper interference look like when it's a mob of fake one-star reviews, or a viral smear campaign on social media, or an AI that's programmed to systematically sabotage a rival's business? That's the brand new playbook that the courts are going to have to figure out.